All right, good afternoon. Are we live, Stacy?
Yes, you are.
Okay. Um, Good afternoon. My name is Norman Leonard, and I'm practice creditors' rights and intellectual property law here in Warren Smith's Asheville office. And with me today is Lily Faulconer, who practices creditors' rights law and business law in our firm's Greenville, North Carolina office. And we want to welcome you to the first of a series of 3 short webinars that we're having this summer to review some issues pertinent to commercial lending and special assets. We're going to be looking at some new cases. We're going to be reviewing some common issues that we see with loans and loan documents that cross our desk. And we're going to be talking about ways to protect and improve the bank's position when it has a defaulted loan. Today, specifically, we'll be discussing some recent case law applicable to a lender's right of set-off. We're going to identify some common mishaps that we see involving personal property collateral, and we're going to discuss a few of the less common types of personal property collateral that lenders sometimes take. So without further delay, I'll hand the program over to Lily to discuss a recent case involving a lender's right of set-off.
Thanks, Norman. Stacy, you can go ahead and kick it off. Thank you. So our first lesson today is how to avoid a fight over a set-off right. And so we'll start by answering a simple question: what is a set-off right? So a set-off right is a legal right that allows for reduction of an amount owed by a debtor to a creditor through the offset of amounts owed by the creditor to the debtor. And so a classic example of this is money in a debtor's bank account being applied to reduce debt owed on a defaulted loan made by the creditor bank to the debtor. Set-off rights can be contractual or equitable. And so when can you use these rights? If you have the set-off right, should you always exercise it? Should you kind of wait and see what your other options are? Obviously, you can't exercise your right of set-off until your loan is in default. But after that, you may decide, oh, there may be other avenues, or I have this right, I'm not sure what to do. Or you may encounter another creditor who wants to collect from your borrower to whose account you have that right of set-off. And so we're going to be discussing that issue today by going over a recent North Carolina Court of Appeals case involving 2 creditors. So this case, Guy M. Turner Incorporated, I'm just going to call them GMT, versus KLO Acquisition LLC, just going to call them KLO. And Stacy, you can just kick it back to that boxing ring because I really want to set the stage here. I want you all to feel just like you are at a very competitive boxing match. I want you to really view this as a brawl. So in one corner of the boxing ring, we have a depository bank, Chase Bank, with set-off rights in a debtor's bank account. In the other corner of the boxing ring, we have GMT, and GMT is a judgment creditor with a garnishment order. So Chase Bank, depository bank with set-off rights, versus GMT, judgment creditor with a garnishment order. And so, if this is going to be a really important fight, what's the prize? And the prize here is going to be hundreds of thousands of dollars that are in 2 bank accounts maintained at Chase Bank by a debtor. And this debtor is KLO Acquisition LLC, and they have 2 accounts with Chase Bank. There's an operating account and a cash collateral account. Norm, do you have a question?
I do not, Lily. I'm sorry.
No, you're fine. So there's 2 operating accounts maintained by KLO at Chase Bank. Like I just said, we have the operating account and the cash collateral account. And Chase Bank had loaned KLO $12 million. KLO is in default on those loans. At the same time, KLO had been sued for breach of contract by GMT, and GMT was awarded an order of attachment, garnishment, and a notice of levy as to those bank accounts at Chase Bank by a North Carolina state court. So GMT serves that notice of levy and that garnishment order on Chase Bank. And Chase Bank immediately sets off that cash collateral account. And Stacy, now you can kick it to get us to round one. And so you're probably thinking, okay, well, they set off one account, maybe they decided to set off the other one. Or you realize that if they'd done that, I wouldn't have a story to tell you today. And so instead of setting off that account, they send a letter that contains the exact text that you see here on the screen. They've taken the right to set off, funds are not available. They let GMT know that. And then they continue to allow KLO unfettered access to that bank account. And that results in millions of dollars flowing through that account, despite that garnishment order that GMT has. So unsurprisingly, GMT sues Chase Bank, who is now paying its attorneys not to collect the debt that KLO owes Chase Bank, but to defend a lawsuit brought by GMT. And so in this first round, the North Carolina trial court rules for GMT. But in the second round, there is a reversal by a divided North Carolina Court of Appeals. And so right now, Chase Bank remains victorious. But what I would like to talk with you all about today is why this wasn't a first round knockout for Chase Bank. And honestly, why was this even a fight at all? And so, Chase Bank as a depository bank had a perfected security interest in those KLO accounts. You perfect your interest in depository accounts through control, and maintaining your accounts with the bank is control. So Chase Bank is set up really nicely there. Chase Bank had that perfected security interest before GMT obtained those garnishment orders. So again, positioned very nicely. There is not a reality where Chase Bank, as the superior secured creditor, should lose to GMT unless Chase Bank waives its right of set off through its conduct after receiving that garnishment order. And so that's what GMT argues to the trial court, that because Chase Bank just sent this letter informing them of the set off right, but not actually taking any action, they had waived that right of set off. And so they shouldn't be allowed to continue to allow KLO access to that account and benefit from that while GMT wasn't collecting what it was owed through that garnishment order. Again, the trial court said that makes sense to us, but the Court of Appeals said, well, actually, it's enough to just assert your set off right. You just have to tell the other creditor that you have this right and that those funds aren't available. You don't actually have to take affirmative steps to exercise that right in order to preserve it. Looking back, Chase Bank may want to act differently. It looks like that this case is going to be headed to the Supreme Court. So for that one final brawl, that rubber match will be at the Supreme Court, and Chase Bank will continue to pay its lawyers to defend this lawsuit rather than to collect on that $12 million debt that it is owed. So one way that Chase Bank could have avoided this lawsuit or worked to ensure an earlier victory was, upon receipt of that garnishment order, go ahead and engage counsel to negotiate a three-party agreement that's going to preserve Chase Bank's rights and also allow GMT some collection opportunity and KLO possibly to continue operating out that account to ensure that operations continue and there's a greater likelihood that everyone can be paid. That agreement could also be used to cut off future litigation right at the start. And so Again, a way this could work is a percentage of funds go to GMT, Chase Bank, and KLO for operations every single month. Chase Bank had all the leverage here to create this kind of agreement that could be worked through between the parties. But as you can see here, they chose not to, and are now kind of dealing with the repercussions of just letting this access continue without really working with GMT to create a resolution before they incurred expensive litigation. And because this is ongoing, right, you may be thinking, well, how does this really impact what I'm doing now? If it's enough to just say I have this set off right, do I really need to care about the implications of this case? And I would say yes. You want to be sure you're exercising caution, you're exercising care when you encounter a situation where you have a set off right, especially a contractual set off right, that you are trying to decide whether or not you want to exercise that right. And you're faced with a creditor who's also really desperate to collect from your borrower. You may want to proactively engage in those kinds of negotiations or agreements, even with this case law as it stands now, to just ensure that no matter what happens at the Supreme Court level, you're protected and you've got agreements that are working for all parties involved. And so a nice cautionary tale to kick it off for you all in summer school. Again, just really be thoughtful and cautious when you are approaching your decision about whether or not to exercise that right of set off. If you have any questions, feel free to put them in that Q&A bubble. We'll address them as we go or at the end. And I'm going to turn it over now to Norman to talk to you about Article 9.
Thanks, Lily. All right, so now we're going to discuss some of the common mishaps that we see when we're reviewing security documents involving personal property collateral. But first, we're going to do a little remedial review, since this is summer school, of the basics of taking personal property as collateral to begin with. So when we talk about personal property collateral, basically we're referring to everything except for real property and fixtures. Most commonly, we're talking about things like equipment, inventory, accounts receivable, motor vehicles, and the like, which you commonly see in your security agreements. But personal property also includes intangible assets that are less commonly taken as collateral, like intellectual property rights and digital assets such as cryptocurrency and other properties that use blockchain technology like NFTs. So taking personal property as collateral is a two-step process. The first step is to create and attach the security interest. Now, there are several elements required to do this. The debtor must have rights in the collateral in order to pledge them to the lender. The lender must be giving value back to the debtor in exchange for the pledge. And there must be a valid security agreement that does all the things that the Uniform Commercial Code says are required. The security agreement has to reasonably identify the collateral. It has to identify the obligation that is being secured by the collateral, and needs to include a granting clause that evidences an intent on the part of the debtor to create a security interest in the collateral. And the security agreement needs to be signed or otherwise authenticated by the debtor. Now, I think it's important to note here that the Uniform Commercial Code, and my discussion here today, I'm referring to the debtor, and I'll be referring to the debtor repeatedly. But the Uniform Commercial Code separates or distinguishes between debtors and obligors. And when we're talking about debtors today and under the Uniform Commercial Code, we're typically talking about the party who is granting you a security interest under your security agreement. And that may or may not be an obligor. The obligor will include your borrower and guarantors and any other parties that are individually or personally obligated for the indebtedness that's being secured. But when we're discussing debtor here today, we're discussing really the grantor under the security agreement. And that may or may not be the same as your borrower or another obligor. So now that we've taken the first step and we've created and attached a security interest with a valid security agreement, we've given the debtor value and all of that, the second step is to perfect the security interest. Now, perfection of a security interest is the legally prescribed method by which we're giving notice of the security interest to other creditors. Perfection is what makes the security interest enforceable against the rest of the world, and especially in the event the debtor files for bankruptcy, which is vitally important. And the method of perfecting a security interest will really depend on the kind of collateral involved. Many, if not most, types of collateral can be perfected by the filing of a UCC financing statement with the appropriate Secretary of State. But there are some types of collateral that must be perfected by different methods. When we're talking about vehicles and titled equipment, for example, the lien of the lender must be notated on the certificate of title that's issued by the state DMV where the vehicle or titled equipment is registered. If we're talking about an asset like cash, money, it can only be perfected by possession. If we're talking about assets like deposit accounts or letters of credit, they need to be perfected under control agreements signed by the debtor in favor of the lender. So now that we've briefly touched on creation and perfection of the security interest, let's discuss some of the common mishaps that we see when we're reviewing loan and security documents. So one category of mishaps involves deficiencies in the lender security agreement. The first kind of deficiency that we sometimes see is where a settlement agreement fails to reasonably identify the collateral. Under the UCC, the collateral must be objectively determinable based on the description in the security agreement. And super generic descriptions of the collateral in the security agreement, like all assets of the debtor or all personal property of the debtor, are not going to be sufficient. The most generality that a lender can really get away with in a security agreement are the common asset categories that are defined under the UCC, which include things like equipment, inventory, accounts receivable, and general intangibles. But certain types of collateral require even more specificity than that, and commercial tort claims are just one example. So it's important to ensure that the security agreement contains an appropriate level of detail about the collateral that you're taking in order to fully capture all of the collateral that's being used to secure the debt. And sometimes we just don't see this. Sometimes we see security agreements that include the all assets of the debtor or very general categories of collateral that are ambiguous and ultimately are going to be difficult to rely on, if not impossible to rely on in court. Second type of mishap that we sometimes see are security agreements signed by the wrong party. Sometimes a lender thinks that a debtor owns the collateral when in fact a related entity of the debtor owns it, or the debtor's principal owns it, or someone else owns it. And on the front end, it's important for a lender to look at the bills of sale, the invoices, and similar documentation surrounding the purchase of the personal property collateral, determine who actually paid for the collateral, and even look at who's paying the city and county taxes on the collateral. All of these facts can be indicative of who actually owns the collateral, so the lender can ensure that the correct party is executing their security agreement. The third type of mishap with security agreements that we sometimes see are missing cross-collateralization terms. And of course, when you have a loan that is in default and multiple loans and a pool of collateral, the lender likes to have options to liquidate the collateral and apply that the proceeds to any of the indebtedness that may be outstanding. Sometimes when we have multiple loans, we see defects in the cross-collateralization language. And this most often happens when you have, say, one secured loan and maybe an unsecured letter of credit to the same debtor or to a family of debtors. And at some point during the credit relationship, such as in a renewal or a loan modification, the parties will insert some language into that document for the line of credit that says something to the effect of, this line of credit is cross-collateralized with loan A. And that's all well and good, but the question is whether or not the definition of the secured obligation in the security agreement will extend to that previously unsecured letter of credit. I'm sorry, line of credit. I keep saying letter of credit. If it doesn't, then that will lead to all sorts of questions to determine whether, in fact, this language that's been inserted in a modification or renewal meets all of the requirements to constitute a security agreement under the UCC. Whether or not it reasonably identifies the collateral, whether or not it sufficiently evidences an intent to grant a security interest, and whether it's signed by the appropriate party. And if it does not meet all of those requirements, then that one reference in the renewal note or the loan modification that simply says this loan is cross-collateralized with another loan will be ineffective to cross-collateralize the loan. But regardless of whether or not it's ultimately sufficient, the safer course is always to have the debtor sign a new security agreement for previously unsecured obligations, specifically pledging the existing collateral as security for the additional debt or the previously unsecured debt. So those are the defects that we sometimes see with security agreements. Now, the second category of mishaps that we sometimes see is a failure to properly perfect a security interest. And most commonly, we're talking about mistakes with the debtor's name on a UCC-1 financing statement. If a debtor is an individual residing in North Carolina, then the name that has to be used on the UCC financing statement is the name as it appears on the most recent unexpired North Carolina driver's license. If the debtor is a North Carolina registered organization, such as an LLC, corporation, a limited partnership, or some other entity that's registered under the laws of the state of North Carolina, then its legal name on the financing statement is going to have to be the name as it exactly appears in what's called the public organic record that was most recently filed with or issued by the North Carolina Secretary of State. And if it's a corporation, this may be the Articles of Incorporation. If it's an LLC, then it could be the Articles of Organization. It's going to be the document that formed the entity. Most importantly, it's not going to be the name of the entity as it appears on the computer screen for the Secretary of State's website when you look up the entity. That does not qualify as the debtor's legal name. You need to go behind that screen, look at the Articles of Incorporation or Organization, and scrutinize those documents and review any amendments to those documents to make sure that you have the debtor's name correct. Very small mistakes can have, on a financing statement, can have catastrophic consequences. Any misspelling, any omission, or any additional matter appearing in the debtor's name in a financing statement could cause the financing statement to not appear in the search results of the debtor's exact legal name and will be considered a seriously misleading and insufficient financing statement. So financing statements really need to be scrutinized, and every effort needs to be made to get the debtor's name correct. The second category of mishaps when it comes to a failure to properly perfect a security interest involves a failure to use the correct method to perfect the security interest. And I think the main stumbling block here involves the difference between titled and untitled equipment. We have seen several loans over the years that when we started reviewing the security agreement, they appeared to include a lot of very specialized, very mobile, heavy equipment. And the security interest was supposedly perfected with the UCC financing statement, but upon further investigation, it was discovered that all of the equipment had titles that were issued by the DMV. The lender's liens had not been stated on any of those titles. And so the lender was unperfected. And in that situation, really the only thing you can do is throw the brakes on, not do anything to push your debtor into a bankruptcy situation or into a situation where they might grant security interest in those assets to someone else, and quietly and quickly perfect your security interest in those assets as quickly as possible, and then wait the 90 days to get past any preference period that might be applicable in bankruptcy before attempting any kind of enforcement efforts. The third type of deficiency when it comes to perfection that we sometimes see is the failure to file a UCC financing statement in the correct place. This is a pretty straightforward one for individuals who are residing in North Carolina and have their primary residence in North Carolina. Then the UCC financing statement needs to be filed in North Carolina. If a debtor has multiple residences, maybe they live part of the time in South Carolina or some other state, then and it's difficult or uncertain to determine where the debtor's primary residence is, then the lender should really consider filing financing statements in both states. However, when doing so, you want to follow the law of both states, and that might require using a different name on the financing statement. So it can become quite complex when that situation arises. For registered organizations, again, it's pretty straightforward. A corporation or LLC that's registered under the laws of a particular state is deemed to be located in that state. And generally speaking, the UCC financing statement needs to be filed in that state where the debtor is incorporated or organized. The third general category of mishaps that we often see involve a lender's failure to maintain perfection of their security interest, either in whole or in part, throughout the course of the lending relationship. And most commonly, this happens when there's an accidental lapse of a UCC-1 financing statement. Financing statement is effective for 5 years, and everyone knows that you can file a continuation of that financing statement within the 6-month period before that expiration. But mistakes happen. Systems designed to protect lenders sometimes fail. And in that situation, if a UCC financing statement lapses, the only thing that a lender can do is file a new financing statement. It cannot go back and resurrect a financing statement that has lapsed. The second, and perhaps a related mishap involving UCC termination, is where a lender accidentally terminates a UCC financing statement. And this sometimes happens where there are cross-collateralized loans. One of them has been paid off, and that loan that was paid was the only loan that was linked to the financing statement in the lender's computer system, and the system prompts an employee to terminate the financing statement, and they do so without being aware of the bigger picture, the entire loan relationship, and they're unaware that that financing statement was actually what perfected the collateral that secured a different loan. And again, in this situation, if that happens, the financing statement cannot be resurrected. The only thing a lender can do is file a new financing statement and obtain a new priority date as opposed with respect to their security interest. Still, a third type of accidental or failure to maintain perfection involves the accidental termination of a security interest. And this is just, again, the scenario where you have multiple loans involved. Perhaps there's only one security agreement that a lender is relying on to secure all of the indebtedness, and the lender allows one loan to be paid off with another loan. They believe that there's crisscrossing guarantees, and that an existing security agreement by the guarantor will be valid and effective to secure the debt that was used to be owed by that entity, but now is merely guaranteed by that entity. But in that situation, sometimes it really depends on whether or not the security agreement is going to be broad enough to cover that guaranteed obligations. We've seen security agreements that arguably cannot be extended to guaranteed obligations. In those situations where the only thing you can do is have them execute a new security agreement that covers that specifically covers guaranteed obligations. The fourth and the final two types of mishaps really involve changes to the debtor's location and changes to the debtor's name that might occur during the life of the loan. If the debtor changes its principal residence, or if it's an entity that mergers or is acquired by another company, the location of the debtor may change. And if that occurs, a lender only has 4 months in which to file a new financing statement in a new jurisdiction before the creditor becomes unperfected in their existing collateral. For changes in the debtor's name, if the debtor's name on its driver's license changes, or if the debtor amends their corporate documents to change their new name to something else, then a lender's financing statement can become seriously misleading. If that happens, the lender only has 4 months to amend their financing statement to correct the name of the debtor to the debtor's new name. And if the creditor fails to do so, they will retain perfection as to all existing collateral, but they may become unperfected as to after acquired collateral, such as accounts and inventory. And for assets like that that are constantly circulating, becoming unperfected and after acquired collateral can be a significant problem and disadvantage, because the value of your security interest can quickly diminish as those assets circulate. So those are just some of the mishaps that we see involving Article 9 transactions. And I wanted to move on from that to briefly discuss some assets that are less commonly taken as collateral, but which a lender might consider if it is offered by their borrower, or if a lender is just looking to take additional collateral to shore up their position. And specifically today, we want to discuss a little bit about intellectual property and digital assets, such as cryptocurrency and non-fungible tokens. So there are at least 4 different types of intellectual property that a lender might consider taking as collateral for a debt. The first type of IP are copyrights. These include original creative works of authors. A copyrighted work might include a written work such as a novel. It could include a musical work, a graphical work such as a painting, or even a very technical work like software. Federal registration of copyrights with the U.S. Copyright Office is not required, so copyrights can exist in either registered or unregistered form. The second type of collateral, IP collateral, that you might take are patents. There are various types of patents. There are utility patents that cover new and useful inventions. There are design patents that cover new ornamental product designs. And there are even plant patents that cover new varieties of asexually reproducing plants. Unlike other forms of IP, a patent has to be approved and issued by the U.S. Patent and Trademark Office to be valid. The third type of IP that you might take as collateral are trademarks. Trademarks include words, logos, designs, or any combinations of those things that make up a brand. A brand, as you probably know, identifies and distinguishes the goods and services of one party from those of another. Trademarks can be recognized by either the state or the federal level, and they can be registered at both the state level with the appropriate Secretary of State or at the federal level with the USPTO. The last type of IP that you might take as collateral includes trade secrets. Now, trade secrets are any valuable or confidential business information that gives one company a competitive advantage over another. The classic example of a trade secret is a secret product formula for a product, such as Coca-Cola, but a trade secret can be any kind of valuable and confidential information. Now, there's when taking IP as collateral, a lender needs to do its due diligence first of all. And first, that requires determining whether or not the debtor owns or merely licenses the IP. Now, it may be both. For very complex products, companies often rely on a portfolio of patents that they own themselves, plus a variety of other patents that they are licensing from other companies. Secondly, a lender will want to determine whether or not the IP rights are state rights or federal rights or both. And this could be important to determine the scope of and value of the debtor's IP rights, as well as how to perfect a security interest in those rights. The third consideration is whether or not the IP rights are registered or unregistered. If some of the IP rights are unregistered, then the lender may want to consider whether it is possible or wise to require the debtor to obtain registrations for that IP. Fourth consideration is, like other types of collateral, whether or not the lender will want to search the debtor's title for the IP. UCC filings, tax records, and the records of the U.S. Copyright Office or Patent and Trademark Office can all be searched to determine whether or not there are any outstanding licenses, security interests, or other liens affecting the title to the IP that's being taken as collateral. And finally, if the IP is going to be critical to the lender's collateral position, then they will really want to consider obtaining an opinion from a experienced intellectual property counsel as to whether or not the debtor's IP is valid or whether or not the debtor may actually be infringing the IP of someone else. This can be very critical to determining whether the IP has any real value as collateral. So once you have vetted the IP and determined that you do want to take it as collateral, it's very important to have an appropriate security agreement. An IP security agreement should include appropriate details about the IP, including any federal application or registration numbers. It should avoid any language that might jeopardize the validity of the IP. For as just one example, certain types of trademark applications can actually be rendered void if there's any language in the security agreement that is construed as an assignment of the application rather than as a grant of a security interest. Security interest in certain IP may need to include other assets to be enforceable or to realize the value of the IP. As we already discussed, debtor may be licensing other IP that's necessary to make commercial use of its own IP, and an assignment of a security interest in those license rights may be necessary to continue realizing the value of the debtor's own IP. Also, a security interest in any IP should generally also include a separate security interest in all the royalties and other receivables that are generated from IP. Those are technically accounts receivable, and those will need to be, will constitute separate collateral and will need to be perfected separately from the underlying IP. Security agreement should also include appropriate representations and warranties about the IP, its ownership, and the fact that it's not infringing IP of someone else, so that if the facts and circumstances underlying the IP are not as the lender believed, then it can declare a default and enforce its rights and remedies against the debtor. And an IP security agreement should also include covenants that require the debtor to disclose newly acquired IP that comes into existence during the course of the loan relationship, and to assist the lender with obtaining perfected security interests in that IP. When it comes to perfecting a security interest in IP, the landscape is fairly confusing. For federally registered copyrights, courts have interpreted U.S. copyright laws requiring perfection of a security interest in a registered copyright at the federal level with the U.S. Copyright Office. By contrast, federally registered trademarks and patents must be perfected at the state level by the filing of a UCC financing statement in the jurisdiction where the debtor is located. But a lender should also perfect the security interest in a patent or a trademark at the federal level as well, because some courts have held that certain transferees for value may take a patent or trademark free and clear of the security interest if it is not also registered with the U.S. Patent and Trademark Office. Consequently, when it comes to any federally registered IP, it's really a best practice to perfect it at both the state level using UCC financing statement, and to also perfect it at the federal level by filing a short form security agreement in the chain of title for each patent, trademark, and copyright that is being pledged as collateral. Finally, for unregistered trademarks and copyrights and trade secrets, the only way to perfect a security interest in those is by filing a financing statement with the Secretary of State. So that's just a very general overview of IP as collateral. I think the upshot is that taking collateral in IP can be quite complex. And if the lender is going to rely on IP to support an extension of credit, then they will want to invest some time and resources into engaging counsel to evaluate the IP, to verify the debtor's title in the IP, and to prepare customized loan documents to take and perfect security interest in the IP include all of the related assets that may be necessary to support that IP's value. And you also want to include all the covenants and restrictions on the debtor that are necessary to ensure that your IP will remain enforceable throughout the life of your security interest in the IP will remain enforceable throughout the life of the loan. So with that, I'll hand the presentation back over to Lily to discuss a little bit about taking collateral in digital assets.
Thank you, Norman. So our discussion of digital assets is going to be a pretty high level discussion. It is summer school. After all, we don't want to get too much in the weeds, and this is an evolving area of law. But again, just to kind of touch on what exactly digital assets are. Digital assets include properties that use blockchain technology, and blockchain technology is essentially a technology that is a digital ledger. So it keeps a history of transactions and stores information in blocks, which are linked to one another in a chain. So you can trace the history of transactions, hence blockchain. And blockchain is the underlying technology in cryptocurrency and in non-fungible tokens, which are commonly called NFTs. Crypto and NFTs are different in that cryptocurrency, which is, your Bitcoin, it can be exchanged. You can purchase things with your crypto. You can actually use your crypto to purchase an NFT, but you cannot trade your NFT, hence the name non-fungible token. Once you've purchased that NFT, it's yours. And so an NFT is something that uses blockchain technology to represent pieces of information in an interactive format. And so that could be some kind of digital art. It could be a domain name. It could be a tweet. It could even be real estate. And so once you have that NFT, that value is going to be in the exclusivity of that asset. It's not something that you can trade, versus with your Bitcoin, you can use your Bitcoin to make purchases, and you can store it typically in your digital wallet, which is accessed with a private key. And so we're going to talk briefly about how to take those assets as collateral, whether or not you want to make the decision to take that as collateral, and how you will perfect that interest in collateral. So how is a digital asset defined under the UCC? Well, the answer to this question is one that is a favorite of lawyers, and that's it depends. So depending on the way that your digital asset is held and the jurisdiction that you're in, it could be classified as money, as investment property, or as a general intangible. And the way that you're going to perfect is going to depend on how you classify that property. There are a number of different states who have approached this classification issue differently. There are some states that have explicit laws addressing how to classify cryptocurrency. North Carolina is not one of those states, but typically you will see it classified either as investment property or as a general intangible. So once you have decided how you would like to classify your digital asset, you will need, obviously, to perfect that interest. And so if it's a general intangible, you're probably going to need to file a financing statement. And if it's investment property, you're going to want to control that asset. If it's money, you'll want to possess it. But from a practical perspective, these assets, especially with cryptocurrency, are held in some kind of wallet or some kind of locked environment where you really have to have a private key or some kind of access in order to even know and validate the existence of that asset, of that collateral. And so maintaining control of that wallet, of that private key, is probably going to be your most realistic option if this is the kind of asset that you are really relying on to perfect your security interest in that collateral, or if it's, all of your collateral or digital assets, having that control can help you limit the possibility that your borrower can transfer the assets out of their digital wallet without your knowledge. And so when you're thinking about whether or not you want to take these digital assets as collateral, you want to consider how you're controlling that collateral, how you're planning to enforce your security interest, again, and how that classification of your collateral is going to impact your ability to enforce that interest, and whether or not that interest is perfected. Again, this is an evolving area of law, and so there will probably be regulatory considerations as well, as we move towards an increased usage of this kind of technology, and we see an increase of borrowers trying to pledge these kinds of assets as collateral. So again, another cautionary tale for you. Be very careful in deciding, what exactly you're taking as your collateral. Make sure you understand what kind of digital asset it is that is being pledged. Is it cryptocurrency? Is it an NFT? What is the ability of your borrower to move that asset around without your knowledge? Because a key piece or key feature of this technology is the anonymity and the difficulty to trace some of these assets. And so as you're making those lending decisions and deciding what exactly you'd like to accept as collateral, be thinking about how difficult it may be in the future to collect and to recoup that collateral if needed. With that, we'll open it up for Q&A. And again, feel free to put your questions in that Q&A box, and Norman and I will answer them. So if there's no questions, thank you all so much for attending today. We hope you enjoyed the first session of Special Assets Summer School, and hope that you will join us next month for session 2. That will be in July. I'm sure you'll be hearing from us about that. But if you have any questions or you think of something in the meantime, please don't hesitate to reach out to me or to Norman. We're happy to answer any questions you have or hear your feedback on our presentation. Thanks again.
I think we do have one question that just came in. Does the UCC filing have different priorities via state law, race, state versus the date of the document? I think, without knowing the full context of that question, I think that the answer is that when it comes to a UCC filing, it's a race state type of answer. If the UCC filing will be what perfects your security interest in the asset, assuming that it's an asset that can be perfected by the filing of the UCC statement and you have filed it in the right place. The date of filing of the UCC will usually determine the date of perfection, because that's the date in which third parties have received notice of your security interest in the underlying asset. And so that's why oftentimes I think lenders will file a UCC financing statement even before a transaction is closed, so they can do a last minute title update on the asset before they lend the money. Now this might have This might be different when we're talking about an asset like an asset that is a purchase where you're taking a purchase money securing interest, and you have a certain amount of time in which to file a UCC. But so bottom line is, I think it's going to depend on the type of transaction and assets, but generally speaking, it's a race situation. But if you want to contact me separately offline to discuss the specific situation and the type of asset and the type of transaction, I'd be happy to give you a more definite answer than what I've just given. Lily, do you have anything to add to that?
No.
All right. Are there any other questions? All right. Well, thank you again, just to echo what Lily said, thank you for attending today. And if you do have any questions, feel free to email either myself or Lily separately, and we'll be happy to answer them. Thank you.